welcome to our Talking Tech webinar today. We're going to be talking about how Trellis AI leverages the US trial court system, and we're going to be looking at some best practices in litigation when it comes to using AI. As a former litigator, I'm really excited about this, and I'm joined by Trellis co-founder and CEO Nicole Clark. Nicole is a former litigation attorney. She's been quoted as saying that Trellis was she created Trellis as her own secret weapon, and we'll come on to talk a little bit about what that means. And Nicole will be talking a bit about how Trellis was formed, and also how AI is changing the game for litigators. Hi, Nicole.
Hi there.
Thanks so much for joining me. So we are going to be looking at the functionality of Trellis. We're going to be looking at customer use cases, ROI. Nicole's going to be doing a full demo, which I'm really looking forward to. And then we will come on to talk more towards the end about some best practices in AI. It's obviously such a growing area in all areas, but in litigation it presents its own special challenges, as everyone on this webinar will know. So we're looking at what best practice looks like. Please do enable your chat if you've just joined us. I'm going to mute my notifications. We will be welcoming questions throughout. But tell us about, so Nicole, you've got a really interesting origin story. So tell us a bit about your backstory before the formation of Trellis.
Sure, absolutely. So I was a litigator for a number of years. I practiced a lot of, I started out probably in civil litigation and moved over more into employment, did a lot of class action, wage and hour work, and employment litigation, for those of you who know or have been involved, is heavily litigated and almost always at the state court level, because it's simply where the laws are favorable to bring those types of claims. And so I found myself practicing in state trial court constantly. And I really couldn't believe that we had these great, databases to research Court of Appeals and to research Supreme Court case law. But here we were in the trial court system, state trial court, largest court system in the world, and yet there wasn't a single source of truth, a single database where you could search the state trial court system. And there wasn't any way to be able to pull strategic information, practical information on the judges that we were appearing before, on opposing counsel and their other cases and the ways they tend to litigate. And this data existed, and yet as litigators, we weren't using it, even though we were all practicing in trial court, and it's where every case starts. And so, the idea of being able to utilize this data really percolated for a while in my mind. But the real impetus was when I was writing a summary judgment motion one evening, and I was complaining to my colleague. It was a complicated issue. I didn't know the judge. And I was trying to figure out really how to structure the motion. And my colleague said that he had actually appeared before my same judge previously. And we went back and we checked the file, and there was a ruling by my judge on really the same issue that the judge had handed down a few years earlier. And that was where I could see the answers. I could see the way to structure the motion. I could see the case law to use. And I really stepped back at that point and recognized, look, this data is out there. This incredibly valuable strategic information is out there, but I never would have known it existed. It was hidden in a PDF, in a file I would have never been able to find or look for. And how was it possible that as litigators, we really didn't have this resource when the data existed? And so we started off by saying, I was going to try this for myself. And so we started collecting data in the courts that I was appearing in most often, which was really up and down California, Southern and Northern California. And I used it in my own practice, and it dramatically changed my practice. I went on to win every motion for the next 2 years it gave me ultimately the courage to say, this is something that if it's valuable for me, it's going to be valuable for other litigators. And so went on to launch Trellis after that.
It's incredible that it had that much impact. No wonder that's the point when you started to say that information was your secret weapon.
Yes, absolutely.
So fine. So, and the database now, so it gives you access to state trial, federal, appellate, Supreme Court bankruptcy cases for 46 states.
Well, let's talk about that for a second. So we're historically as the state trial court system, and that's really what we focused on, and everyone knows that. And it's where you can't find that data other places. I mean, we are the leading provider, have more than double anyone else that's out there. But we are expanding now. We're looking to really be able to provide a single source across the trial courts period. So we're extending to federal as well. That will be live by the end of this quarter. Is already available via our API for those of you that want to buy API.
Yeah.
And then with federal, we will be expanding to also have, once we have federal, we'll also have bankruptcy courts, appellate courts, et cetera, within our federal data. But really, we want to make sure that whether you litigate in state trial court or federal court, you're going to be, as a litigator in the trial court system, we're going to be able to provide coverage.
Okay. And your yes, sorry, I should have said about the API. And with and your particular passion or the thing that doesn't make sense, I think you said, is that because there wasn't that data available from the courts where people are actually spending most of their time, right? Like, you're not going to be needing Court of Appeal data a lot of the time. Is that right?
So that's absolutely right. The way that the system works right now, and for anyone who has touched, let's say, the state trial court system, you know what a mess it is. Every county actually hosts their data separately. So, of course, let's say California, 58 counties, all of them host their data separately, maintain it separately. It's in separate formats. There's very little searchability. They're hosted on court websites. And there's no way to search by judge or by legal issue or by a particular attorney. So what we do is we actually go in county by county across the nation for the state trial court system, and we aggregate the data. We structure it. It's unstructured data otherwise, normalize it, and then we make it searchable. And because we do that, we're able then to layer insights on top of that data. And then, of course, now layer on our AI on top of that data foundation.
Yeah, and it's fascinating. So you can do it by a judge, as you've already given. That's perhaps where it started. So by case, by the types of case, by sort of types of outcomes. You can get insights. You can sort of slice it and dice it in so many different ways, depending on what your objective is. So everything. I don't just specialize in litigation tech, but clearly, but what's fascinating is that the common denominator across everything that we talk about when it comes to tech is data, right? And so for you, it's this data, and it's the quality of the data that's absolutely key. Tell me about, why is it difficult to create practical AI for litigators based on the necessary data set available?
Yeah, absolutely. So as we think about this system, the trial court system, right? Every case is going to start in trial court. 99.7% of cases are going to settle before they make it to trial, which means the trial court is really where these cases both live and die. Now, maybe they go through a 1 to 3 year journey before they're getting settled. Very few cases make it to trial. Some do. Wonderful learnings in there as well. But what you're really talking about is this court system where all of the data really lives. The cases, obviously, very few make it to trial, let alone then making it to appeal. So Court of Appeals is a tiny, tiny corpus of data. Whereas the trial court system, right, massive amount of data. But because the trial court system historically has been so fragmented, it really has just been avoided. So there hasn't been this single source, this foundation for trial court data previously. Now, when we're talking about litigation, as we mentioned, litigation is going to be happening in trial courts because that's where most cases both live and die. But when you're trying to get AI to really do, and particularly generative AI, right, generating content, um, you need to have training data that is going to be able to give samples for eventual output that you want. And because really the databases that are out there and the historical legal research that people have done has always been Court of Appeals research, what's out there is Court of Appeals data. And what many of the AI platforms try and use for litigation is Court of Appeals data. Now, that can be helpful in thinking about sort of from a precedent standpoint, but it's not going to be able to help draft excellent, let's say, motion content. And that's simply because Court of Appeals opinions and motions aren't one-to-one for what trial court motions look like. So in order to really draft excellent trial court work product, you have to have that sample training data of the trial court system. And because, as we mentioned, the trial court system has been so fragmented, the data is simply not out there. That's why we're able to do something that many people aren't able to do, is simply, if you think about what we have, hundreds of millions of motions and briefs and judicial rulings and opinions, all at the trial court level, we're able then to create training set, to create work product for drafting motions that is going to be really on point, utilizing the information that we know about judges, utilizing the information that we know about the case law that's being applied currently and the way that judges think about that. All of the years and historical work product of hundreds of thousands of attorneys that has drafted motions and put them on file in the trial court system. And then we're able to use that content where for AI that is out there that is trying to help litigators without that content of the trial court data in the way that we have, it's just really difficult to create output that is going to be extremely useful for a litigator. You simply need that data set. And as we know, that data set is so difficult to harness and we spent so much time and energy doing that, that we're in a place to really help create draft content for litigators in a way that most systems can't.
Interesting. So you launched Trellis AI in November 2024.
That's correct.
Nicole's going to come on to demo Trellis AI for us, which is really cool. But tell me a little bit before you launch into the demo in terms of the underlying model, and perhaps a little bit about, perhaps tell us a little bit about the product.
Absolutely. So again, if you think about every product and that we launch, really think of it as the data as the foundation. As a pyramid with data on the foundation, insights being a higher level, with AI really being the tip of this pyramid, where we're able to use both the insights that we've collected as well as the underlying data to really create this output. And so we are a tool specifically for litigators, specifically for trial court litigators. And we create work product for the attorneys, and I'll be able to show that. We shy away from a chat interface. What we found when we spoke to litigators was that chatting for research was great, but what they ended up needing to do ultimately was turning those chat responses into work product of some sort, whether it be communication to a client or drafting a motion or what have you, and really needing to, so it was almost homework that they had to take, creating it from chat responses to the work product. And we said, we want to sort of intermediate that layer. What if we can create the draft work product for them? We don't need the attorneys to be incredible prompters. You're not going to get different output if you are a great prompter versus an okay prompter. We do all that work for you. So what we do is we really work on creating one-click solutions where there is a task or output or work product that you're looking for, and it's simply a button. And you can do that. And what you're able to do is really use our database, our content. So in many ways, you don't need to upload a ton of your own data. Now, we can talk about that in areas where it's really useful.
Yeah, and do you know, I want to come on to talk about, because you've obviously got your various buckets, in terms of what the product looks like. So you've got you've got research, you've got work product, you've got discovery. Yep. I think I may come back to those, but I think what would be so helpful perhaps is if we dive into the demo, because I think some of this is going to come out, and then perhaps I'll come back to that to the extent that you haven't, especially cover it. But and then just to say to anybody listening, so if you've got questions about the demo, please put it in the chat. Very happy to answer it either during or after as appropriate. And then obviously we'll come on to talk about wider best practices. But yeah, if I can just hand over to you, Nicole, and I may ask questions as we go, if that's okay.
Oh, please do. Absolutely. Okay, so I'm going to share my screen. All right. Are you able to see my screen?
Yes, thank you.
Okay, perfect. So right now I'm on our homepage. For those of you who are existing customers or know Trellis, you know what we do, right? You can search the entire state trial court system from a single search bar. You can search across, you can search individual states. When you're searching a state, you're searching across all the courts in that state. You can narrow from there. What I'm going to do is just pull up a particular case to show you how easy it is to get into the AI system. So one of the nice things about Trellis, as everyone probably knows, is you don't have to know your case number. You can search by a party, or you can search by a legal issue, what have you. I'm going to pull up a disability discrimination case. All right, so here I am jumping into Rago v. Stores. And right now I'm on the docket of this case. Most folks know what our docket pages look like, a lot of metadata about the case, a lot of information you might find on a court website enhanced with a lot of additional information. We enhance with the underlying law firms that the attorneys practice from. We tell you who all the parties are, who's counsel for who, all the documents that are filed. You can jump into those as well as the case events. But I want to open this up in the AI workspace. So the way that we think about our AI is really on two levels. We think about it at a case level, and we think about it at a document level. So at the case level, what we're doing is we're looking at everything about the case. Of course, all the metadata about the case, the judge, the parties, the practice areas, the documents that were filed, all of the events in the case, right? We have all of that information. And so that's really at a case level, the way we're able to dive in. At a case level is also how we think about drafting arguments or motions for the particular case. And then a little later, I'll show you how we think about it at a document level as well. But at a case level, what I wanted to start by showing you is our case report. This is a report for attorneys from the very start of a case. You can run it at the moment that you get the complaint. So right now I have just run our case report. And what is a case report? A case report, think about it as the entire playbook for your case. This is going to be based on everything we know about this case, as well as the thousands of other cases that have similar facts, similar causes of action, that we have the data on how those have played out across the trial court system. So we're able to really combine the strategic of what needs to be proven at trial. What are the legal thresholds? How are the facts supporting those thresholds so far? What's the narrative for trial? Down to the tactical. What are the next steps that need to be taken? So let's review some of the info in here. So first, you're going to get the case info, including all the info for how to contact counsel in the case. Always have it handy. I like to think of it almost as sort of a Bible for the case, where you go to really understand everything about the case from the start. You can have all the causes of action pulled out for you. Factual background, you can dig in. In this case, it's a disability discrimination case where the plaintiff suffered a major depressive disorder, asked for various flexible work schedules, and now he is suing based on the fact that he doesn't feel like his disability was accommodated. What we do then are some of the tasks that litigators need to do from the start of a case. They need to understand the key facts of the case by party, who's involved in what. But there's other ways to think about understanding the key facts. You can also think about it from a chronological standpoint. So we go ahead and do that as well. What we want to do is really, attorneys are doing different tasks at different times, and they need to think about the facts of their case in different ways. So we go ahead and give all that work product to you upfront from the very start. Next, we're going to actually dig in analyzing the elements. And we're able to do this because we have these hundreds of millions of documents and motions that have been filed on these exact issues. So when we analyze the elements, we not only analyze the law, right? Under FEHA, claim for disability discrimination requires, and then of course the elements. And we're able to pull this because we have so much attorney work product that is in their motions with law and argument analysis. But then we actually match that to the facts. The facts so far, this is based only on the complaint at this point, is exactly what the plaintiff has alleged that support each particular cause of action. So we go ahead and give you that info right up front so you can dig in there. What about the relief sought? Very quickly understanding, are they asking for punitive damages? Are they asking for attorney's fees? This really can change the way you think about a case strategically, making sure you have all that information up front. Statutes of limitations, are there any statutes that apply to this? And what exactly is going to be the deadline for filing? Whether you need to think about it from a filing perspective, or you should be thinking about it from an affirmative defense perspective. Then we go into legal defenses. So based on all the knowledge that we have of similar cases and cases that have been successful at trial, what were the defenses that were used against, we're looking at this from a defense perspective right now. The legitimate non-discriminatory reason that the employee was terminated that didn't have to do about their disability. So all of these defenses to each of these causes of action that we have seen based on the data be successful in other cases. So again, we're able to pull both from everything that we know about this particular case, as well as our entire database of hundreds of millions of other cases and the cases that are most similar to this case and how those have played out. We next dig into some of the procedural tactics. Are there reasons that a motion to dismiss might be a better move in this case than, say, answering the complaint? And we go through what we can see based on the data for there. Now we start getting into the tactical. What is your response deadline? For discovery, you're going to start to need doing some discovery prep. What's the key evidence that has been outlined so far in this case on both sides, both for the plaintiff and for the defendant? What about witnesses that we know of already? Who has been listed and what do you need to know about them when you're thinking about noticing depots and getting started, and then what you're going to depose them about, how they fit into the narrative of this case. We do a deep dive on each of these.
Can I jump in, Nicole? I'm just conscious of this is so much information, and if I leave it to the end, I might lose the plot, which is not the first time. So just how do people know that this is right? This is what the case, with all of these AI products, people may be listening going, oh, well, how do I know that this is right? And that's always the question that we have to kind of answer. How can they be restricted? I think it's fascinating in terms of the amount of information that you're including. How, for example, in terms of including what's relevant at the beginning, how do they know that information is correct?
Well, the great news is that everything sources to our documents and to our cases. So they can go directly to the complaint and see the facts that we are alleging here. They can go to other cases that we've identified as similar to this case, and they can see the information there. So with everything, if you think about what our generative content is, it's not an open system. It's not going out and asking OpenAI an open-ended question. I have a disability discrimination case. What do you think? Right? Everything is a closed system, meaning we have the underlying data to be able to answer these questions. So there isn't the same concern for hallucinations. That's not to say hallucinations never exist, and I wouldn't say that I don't think you should trust anyone who does, but what I will say is hallucinations tend to take place when you ask a question the model does not have an answer, and so it makes one up. That simply isn't the case with what we do, because everything points to documents, everything points to cases, to insights, to analytics that we've already gathered that you can go to and see the underlying information for.
So important. Okay, yeah, no, absolutely. I think anything without sourcing is difficult to trust, right? When you're done, I'd love to come back to the strategic, the strategy side, but by all means carry on. I think if we've got time to do a bit of a deeper dive into that, that would be great. So yeah.
Absolutely. I'll show you some of the strategic things. So we're more in tactical right now, but there's some other strategic information like jury information, verdict analysis, right? Information that we're able to pull because we have all of these verdicts across our databases. So how can you think about that sort of information? So we try and do a lot of the strategic along with the tactical. And one of the reasons that we really do this is because, you know, for attorneys and particularly for litigators, and you can talk about let's say associates that might be doing a lot of the drafting of work product in these cases. I know for me and for so many of the litigators that we speak with and talk to that it is many years before they actually take a case to trial. So they will be doing so much of this practical work, but it's really myopic. They're doing discovery work and they don't get to see how that discovery ultimately assists in the narrative at trial and how it all works together. What's really nice about what we produce here is that they can see the full picture. They can see what that narrative should look like at trial, but then they can also see tactical next steps to get to the next place. And that helps really put the picture together for them. So it's an excellent training tool for associates. We also find that our customers tell us that when they're bringing on new colleagues to ramp up to cases, this is exactly what they need to ramp up to a case quickly. Also, when they're appearing before a judge, they need to go on a case management conference and they need to quickly remind themselves everything about the case so that they are going to be prepared when the judge asks questions. It's a really great primer to dive back in for that as well. So we try and really combine the ability to see high level, what is the legal analysis, what needs to be proven, what are the discovery that still needs to be done in order for you to prove that narrative, the elements, where are the gaps so far, and then how do those need to come together, as well as really settlement strategy. How should you be thinking about settlement early on in a case like this? What can we see about you know, what we know from other cases as to whether settlement might be a good idea. And of course, taking that into consideration with the goals of your client are always going to be essential.
But real practical real practical tips. So for example, just taking, we've gone off it slightly, but where it says the witness should testify as to X, Y, Z, that's taken, just to be clear, is that taken from a successful motion, whatever it might be, in that particular type of case, that particular type of motion where it was successful? On what basis does it say they should testify in a certain way?
It's actually a combination of those things. It's such a great question. And it's why all of these, they may seem like simple concepts, but there's so much going on under the hood to be able to support this information. So it's taken from two things, or really a variety of things. One is, okay, you've got a legal threshold that needs to be proven for this cause of action. You've got elements that need to be proven. We know what those are because, of course, we see hundreds of case law being cited about similar things in similar cases. But it's not only that, it's combining that with the facts that we know about this case. So what do we know about Mark Bonzel? We know that he was a supervisor for plaintiff from 2020 until his termination. Based on what needs to be proven or your defenses that need to be proven, what is he going to need to testify based on the facts of this case? So everything is the combination. It's not simply law, which is something you might think about from if you were doing Court of Appeals research. You're thinking really strictly from a legal perspective on, you know, what is the appellate law that's binding. But it doesn't come back to what we do, which is based on the facts of your case, which of course we have because we have all these underlying cases and documents. how do the facts play into what needs to be proven in this case? And what, in this case, specifically, will Mr. Bonzell need to testify to in order to, in this case, as a direct supervisor, be able to defend this case for disability discrimination based on what we know from similar cases, similar testimony, and bringing in the facts of this case?
It is, you're absolutely right. So compared to some of the other things where I've written about or had demos, it's much more practical, much more sort of like in the nitty gritty and the day-to-day workflow of a litigator, rather than being, and let's talk about this case law, etc., which where a lot of them, the AI I've seen has been focused.
That's exactly right. And that's still great. It's good from a research perspective. But as I mentioned, an attorney will then, let's say he's figuring out how to start to prep Mr. Bonzell for a deposition. The attorney's going to then need to connect the facts of this case to that case law that it's seeing maybe on another platform. This is where we do the connection for them, and we're able to really get into something that will tactically help them with workflows for next steps in their case, rather than, as I mentioned, needing to somehow turn chat responses into work product by the attorney then needing to apply the facts of the case to the law that they just researched.
Okay, I'm going to come on to talk about customer use cases and also ROI, perhaps after the demo. But if, as you go, I don't want to interrupt your demo too much. if at any point you want to do it during, that's fine. But otherwise, we'll just address it afterwards. But I'm fascinated as to how people are using this in anger, as it were.
Let's go next. I want to show you some of our draft argument output, and then we'll talk about ROI specifically. So let's go to draft arguments. And right now I'm going to say I want to motion for summary judgment. There's a variety of different motions you can create output for. Again, I'm using the complaint of this case. Now, do note that I can upload additional facts. I can upload additional information. If I have my undisputed material facts, I can upload those. I don't need, of course, Trellis has the complaint on this case as it has hundreds of millions of others. But if you want to put in your own information, of course you can too. The nice thing is you don't need to for in many cases because we have so much of this data. So I'm just going to press draft arguments. And what it's doing now is really creating this draft argument output. Let me take us to the top for a second. So here we are, table of contents. Our draft arguments, this is, again, these are going to be draft arguments for a summary judgment motion in this case that we've just been looking at. And our arguments are specific by cause of action. We go deep dive into each cause of action, really with the goal that you should be able to copy paste the arguments into your motion and be able to move forward. So of course, again, we outline the specific causes of action, the statutes that each of them rely on. Then, of course, the case facts. This is going to be a very deep dive into all the case facts. There's a lot of information in this case so far, but let's just jump into, in this case, the disability discrimination case. So then we go and we say, okay, what are the specific facts that were alleged that are key to this cause of action? So in this case, a summary judgment motion is often brought by the defense, trying to get rid of a cause of action or hopefully the entire case in many cases. So here we say plaintiff's disability failed because he was unable to perform the essential functions of his job, even with reasonable accommodation. What's really beautiful about the draft arguments that we do is this ability to apply facts to law, like we just talked about. Let me explain to you a little bit of the technology for how we do this. So we have, let's say in this case, we're simply going from the complaint. We have the complaint of this case. We know the facts. The next step is we find across our system, searching for thousands of cases with the most similar facts and the most similar causes of action. From there, we look at the motions for summary judgment that were brought in those cases, those underlying documents. We then really evaluate the arguments that are made in those motions based on outcomes, based on a variety of other factors that we look at. And then from there, we pull out the strongest arguments, the strongest case law. And so that's what we do here. We then provide it back in an IRAC format. So here, obviously the issue, he wasn't able to perform even with a reasonable accommodation. Then, of course, what is the law? Plaintiff must show he suffered from a disability, he's a qualified individual, that he can perform the job without reasonable accommodation. We give you the case law, you can always jump in. Also, everything, as I mentioned, is sourced. You can jump in very quickly to see exactly where, what is the concept that we're alleging here, and you can jump directly into the source. The source will pull from a document that was an excellent winning motion where you can see that this argument was alleged. So you can really get the comfortability of where this came from. And then, of course, you can dive directly. We're going to pull the argument that we think is most effective for this, but you can jump directly into the underlying document. You can jump to the case if you want. Jumping back, go for it.
Sorry, thank you. So rather than having, you said about attorneys not wanting a chat function. So rather than perhaps having a chat function and conversing and saying, you know, what was this argument, what was that argument, and then creating their own, perhaps using prompts as well, but if having a bit more involvement in the output, you've decided that this is the best way in terms of, it's almost like decided for them. Is that fair?
It's decided for them. If you think about what we're doing, we have our attorney analysts are testing thousands and thousands of output and iterating and making it better. And what we're doing is we're taking away attorneys having to become prompt engineers. You can rely on the fact that we go through thousands of testing before we then iterate and test again thousands of times. So yes, we try and take away what could otherwise make a good output or make a bad output simply by the strength of the prompt of the user. And we say, let us do that work for you. We know what you're trying to accomplish. We know how the technology works, and we're iterating and testing thousands of times. This is the best quality output, and let us do that real work for you. And go ahead.
No, sorry, I just said really interesting. If anyone's got any questions, jump in on the chat. But I think that's, I mean, it's different, and it's interesting. Yeah, sorry, carry on.
The thing that I'm most proud of that we do here, and again is something you saw a little bit of it in case report or case assessment, but that you can see here, is we don't stop at finding the best arguments from other motions. That would be one thing, and it's incredibly useful and incredibly strategic. But what we're able to do then is apply facts to law. Here's an example, right? In this case, plaintiff was employed from this date to this date. They suffered a major depressive disorder. They got a physician's note, right? The actual facts of the case. So we're not only saying the law, we're saying the facts of the case, and then we're applying the facts to the law. That is the crux of legal writing. And that's what we're able to do given our data that other platforms simply can't do. And that's a lot of what I mean about that litigation output, that creating that motion drafting like this is so difficult to achieve, because they simply don't have the underlying sample data, testing data that we have to be able to do this. And then, of course, concluding, and we do this over and over again, cause of action by cause of action, best arguments, actual facts of the case applied to the law. And then conclusion, right? Loose IRAC format, very strong, where the output can be taken directly. Of course, everything can be sourced, everything can be checked. So we're incredibly proud of what we're able to do in the motion and argument generation capacity.
Yeah, no, it's very impressive. There's a question, they said that you might get to it, but just so that people feel they can jump in with questions as we go, I'm going to just ask it. So I'm guessing Nicole will get to this, but what if you also have interrogatory answers, deposition transcripts, expert reports, medical or other relevant records? How does Trellis accommodate those additional facts?
Yes, please. We obviously, we have a massive amount of data, but you might have information that isn't on file, right? Exactly like you're talking about, deposition testimony, medical records. You simply upload those, and we take those into consideration as well when we're taking facts of the case. You can do the same thing for creating timelines across all of documents that you want. Those can all be done in the AI workspace, I can say that I want to take, a variety here. I'll jump into a case that I want all of these documents and I want to create a timeline off of those documents. The same thing, there's an area that we were just in the case aspect for draft arguments or for a case report where you can upload any information. Of course, you can upload it here. And you can take that information into consideration as well when we're creating the draft output for you. So yes, we fully support that.
And I know that, sorry, I'll come back to your question, just the second part. From a security perspective, obviously you've got a lot of information which is public domain, which you've curated. So you've taken a lot of publicly accessible unstructured data, you've done a lot of work to it and you've made it accessible. In terms of the uploading anything that's confidential, presumably you also have to answer a lot of questions in terms of security and training the model and all of that. How do you, perhaps it's worth touching, I know we've got someone who's here from the security world, so it might be worth touching on that now.
Yeah, absolutely. Look, we work with top law firms, and security is, a huge priority to us. We follow all SOC 2 standards. All of our data is encrypted at rest. For enterprise users, we have any uploaded data goes into the vault. The vault is encrypted. It is so secure that even Trellis can't access it. So we take a lot of pride in our security work. We work with security teams. We go through security reviews regularly. So yes, we have put a lot of effort into making sure that everything is entirely secure.
It's funny because great minds think alike, because I hadn't read the second part of the question. The second part of the question is, are the uploaded documents then used in your training data, or are they private to me and my firm? So we think alike. I suppose it's natural, but I think you've answered that really.
We never train on user data. We never, again, we can't even access anything that's uploaded by our users. Trellis doesn't have access to that as well. Everything's deleted. We do not allow any training on user data. Even the output that you generate will be deleted within 30 days unless the user saves it. So yes, we would never train on user data. That's why we do so much work on our side to make sure that we have incredible output that is entirely separate from anything that you would upload.
Yeah. In terms of ROI, like whilst we're in the demo, like just talk through. It's very difficult to measure sometimes, and it's across different types of legal tech, it's sometimes easier, harder to talk through, to the extent that you're able to, what ROI firms are reporting or able to report.
Absolutely. So I have some exciting different areas to talk about ROI. So we were just in draft arguments. What's the ROI there? I mean, for anyone who's drafted a summary judgment motion or their teams, that this can be a month-long process, many times more. It is a huge, massive beast. Users save at least 15 hours is what they've reported for drafting summary judgment motions, as well as our other dispositive motions that we provide as well. So huge time savings, and that is on the lower end. There are many cases where they have told us that they've saved even more time than that. Really proud of that. Let's talk about ROI and some of the use cases for the case report and case assessment that we looked at first. We have some really interesting workflows that our customers have worked with us on, where they actually want the case report to be delivered to the attorneys at the start of the case. This means within a workflow. They don't even want the attorneys to have to go onto Trellis to press the button. They want right information at the right time. Get the attorneys the case report with all of that analysis from the start of the case. So we work with workflows with our customers to deliver that data. Think of it as a push rather than pull. Push the data to the users at the right time, and we can create those workflows. Another thing that they're doing, which is really interesting with some of our users, is they're going even a step before a case is assigned, and they're looking at it from a business development perspective. We can actually set up case reports to be directly within any alerting platform or alerting systems that you use. Some people use CNS, some people use Trellis. There's a variety of other alerting platforms out there, dingers that people use, where we can sync in with those, and you can have the case report that is delivered at the same time as you see the alert. This allows not only the attorneys to have information on clients and to be able to go back and say to the client, look, you've been sued, and to have a ton of information about the case. But for prospective clients, they're able to go in with incredibly useful information. We're even seeing this business development work in other sides of the firm. So they'll actually have dingers where the transactional attorneys have great relationships with a client, but they can now see the case report so they can cross-market their litigation services to particular clients. So we've seen some really interesting work in creating workflows to get the information all the way at the business development standpoint. Of course, being able to bring in new business, more than pays for a year of Trellis. And we've heard some incredible anecdotes about some of those stories of the business that they've been able to bring in so far. And it is so early. We released in November, and we're already seeing these great responses.
Yeah. Yeah, it's probably a conversation because we haven't got time, but I'm fascinated because the broad approach of, taking a position on this is how it should be done. I do think that that's going to open up really fascinating use cases in terms of, sort of culturally what that translates to in the firm in terms of how litigation is delivered. There was a question I need to come to. So, what LLM is being leveraged to power your Gen AI capabilities?
Absolutely. It's a great question. And I can tell you we didn't get into some of the other AI. We do a lot of on-document AI as well, whether it's creating a timeline or pulling out key witnesses or extracting citations or all that work on documents. It depends on the tool that you're using, is going to depend on the model that we're using. We're constantly evaluating and updating as well. Right now, we primarily use Anthropic and OpenAI. For Anthropic, we use Sonnet, Opus 3.5. For OpenAI, we tend to use 4.0, 0.1, and 0.3. We're even playing with Deep Research now, which has some exciting stuff coming out. So I will say it's going to depend on the tool that you're using. We do so much testing on the back end to make sure that the quality of the output is number one in really what are the metrics and the KPIs that we shoot for, and we use the right model for the right quality of output.
That's interesting. That's the way I think it should be. So you're testing in terms of, because all the different models have got better capabilities. So you've got a team testing to make sure that you use the right model for the right work.
Absolutely. And then always testing where their models are changing and updating constantly, and testing on new ones as they come out to see, always ensuring, can we get better? Can we do better?
And presumably maybe from a cost perspective as well, because obviously certain, some of them are meant for certain tasks. Anyway, we can come to that. But so ethics, it's funny because I wrote, the ethics around AI is something that's so much in the press at the moment. You've got that, it's not applicable directly to this conversation, but the AI Act in Europe, you've got lots of considerations around the world about ethical use of AI. Tell me about how that impacts on this. Like how are we seeing, what would you say would be best practice for people looking at this, perhaps who haven't been using an AI tool but are concerned about the ethics or concerned about transparency or what have you? What are you seeing in terms of best practice?
Well, what I would say for users is that really you should go out and try the models. It's going to be the best way to be able to test any legal technology, is to go directly sign up for a free account on Anthropic. Don't put in sensitive client information. That, of course, is a best practice. Get comfortable with asking questions and seeing the output. That's the best way that you're going to understand how the technology, what is table stakes. For then, when you can evaluate legal technology providers, then you can see what is the level of value that they're providing on top of these models, and you're going to be able to make better informed decisions. In terms of best practices for security, of course, If you're using look at the terms of service. If you're using a free version of one of these, they are training on your data. Just be aware of that. We do a lot of work to ensure, obviously, that no training is allowed on any of our data and any of our users' data. So you always want to check with the provider. You want to go through security reviews. You want to really build a level of confidence that you feel secure with the data, because this is obviously in many ways, for law firms, the data is not their data, it's their client's data. And you always want to be thoughtful about that. In terms of really ethical considerations, I think the ethics are, and there's various ways to think about ethics. There's, are we going to have robot judges, and what are the ethics of that, right? So there's a lot of murky area for so many things we could think about. But in terms of using a technology, I think ethically, right, you have your professional rules of responsibility that require you to stay abreast of changes in technology. And from a professional responsibility perspective, you should be aware of what's out there, how it can benefit your practice, and how it can benefit your client. And in many of these cases, this work being done, being able to be more efficient, can actually benefit your client greatly, and can allow you to even develop a case more, to be able to do information. The way I used to think about it was there was always more to do on a case that I just didn't have time for. And this frees up the ability to do some of that work that you wish you could do that would be a benefit to your client, but you otherwise just didn't have time for, given deadlines. And so I actually think you should really be thinking about the ethical implications of not taking advantage of technology, and at the very least, be able to evaluate whether it is a benefit for you. It might not be, and that's great, but you should be evaluating.
I feel like litigation, because it's always been at the forefront of AI. Like, you've had e-discovery for years. I've had lots of discussions around technology assisted review, and how it kind of paved the way, right? You look back to those the case law, and it just seems so long ago now, right? That everyone was like, oh, can we really do this? And I think that litigation has paved the way, and now it's so interesting, because I think that we've got a lot to learn from the litigation sector in terms of how to adopt these new changes, and what we've learned from those examples around things that perhaps were uncomfortable in these transition periods. And now the argument is that we're moving from technology assisted review to human assisted review, which I think is going to be,
I love that.
And it's a transition period, right? But we've got plenty of previous inflection points, haven't we, where there's been some big changes, and it's caused a lot of upset in case law and everything, and then in the end it's settled down, and people go, actually, this is far more efficient. And like you said, actually you can do far more, like technology assisted review. You can do much deeper dives, you can go much further. You can use now Gen AI to mean that you can surface more information. Obviously, you have to be extremely careful in how you do it, and this is where these conversations around security and sourcing are so important, right?
Absolutely.
I think we're almost at time. I think, do you think maybe one last question? So maybe I've just sort of touched on some of those things, but how do you think that AI is touching every part of the law, right? Like, so we're having this conversation. I write about contracts, I write about everything, but how does litigation, and perhaps the people that you're speaking to and the work that you're doing, do you think, how does it differ in the challenges that you're facing, or clients are facing at the moment, in the application of AI?
Absolutely. So I think when we think about some of the areas where AI will be able to transform the industry, and really, with lawyers being the assistants, if you will, in contracts, I think that when you think about that data, it's contracts have basic provisions, there's structure to the documents. There's that was an area where AI could easily come in and transform things. And I think that we will dramatically see a shift in what transactional practice looks like very quickly. I think with litigation, right, there's so much art combined with science, and the facts are so essential. And it's why I'm so proud of what we're able to do with applying facts to law. But litigation, I do not see a universe where there won't be litigators. I think the tools that litigators use will get better and better. And I think there's slowly going to be, I think, we're looking at this transformation. We're in this transformation period and we're looking and we're saying, okay, it's happening. When will we cross over to where that is industry standard? Will it be 2 years? Will it be 5 years? I think we can all look and see that it's coming. It's a question of really when, how long will it take? And the tools are getting better and better during that time. But I don't think, I think given the amount of data, given the unstructured nature, it's reasons why we're able to do things that other people can't. And it's reasons that it will take a little bit longer to really lock in being able to utilize these tools for the vast array of litigation, workflows, litigation tasks. You're still going to be deposing your client, but you may have help with thinking through deposition questions and thinking through the facts of the case and having those at your fingertips in a different way. So I do think that there are areas of law that are that are much more simple for AI to take over very, very quickly, and really change what the number of jobs and the way that I do not see that in litigation. Litigation, there will need to be humans, especially given the vast amount of information, given the need to apply nuance and sort of be strategic. And these tools are getting better and better. I mean, we're incredibly proud of where we are. And I think we're on a journey of what's only going to be, better and better as we move forward, as these models get better, as they get less expensive. So it's an exciting time. But litigation is very different from transactional work. I will say that.
Yeah, it's completely different. It's super fun. I have to say, as a former litigator, I've got a big passion for seeing how the tools are developing in this space. There's a question that was put in the Q&A, which I will send to you, and we will get to your question. I apologize. It was a late minute question, and we will come to it. We can answer that afterwards because we haven't got time to dive into it now. But look, thank you to everybody who's joined us. I so appreciate it. Thank you for your questions. We can continue the dialogue afterwards in chat. And Nicole, it's been fascinating. Thank you for that demo. It's so great to see it, the functionality in practice. So I appreciate you spending the time to go through that with us, and thank you to everybody for joining us. I've really enjoyed our conversation and look forward to speaking to you again soon.
Thanks, guys.
Thank you.